जी अस्सलाम वालेकुम जी. Hopefully all of you are fine and doing good. One of the most important uh, numbers in 2022 is 22 itself, क्योंकि आज CP नंबर सिविल पिटिशन नंबर 22 ऑफ 2022 का ऑर्डर आया. 26/7/2022 आज डेट है. और आई वुड से सुप्रीम कोर्ट का वन ऑफ द मोस्ट एक्सपेक्टेड, वन ऑफ द मोस्ट स्ट्रेट फॉरवर्ड डिसीजंस ऑफ 2022. ये हाईली एक्सपेक्टेड था, ना सिर्फ जूरिस्ट की तरफ से, ना सिर्फ लीगल एक्सपर्ट्स की तरफ से, बट आम पब्लिक की तरफ से भी. दिस इज़ ओपन एंड शट केस जो हम नॉर्मली रूटीन में यूज़ करते हैं नोशन, लेकिन इस पर परफेक्टली एप्लीकेबल थी. क्यों एप्लीकेबल थी? इसलिए एप्लीकेबल थी कि 63A की जो एक इंटरप्रिटेशन सुप्रीम कोर्ट ने की वाया प्रीवियस ऑर्डर, उसकी जो है फर्दर एक्सप्लेनेशन थी, और उसकी बेसिस पे ऑर्डर पास किए गए बाय द प्रोविंशियल असेंबली, जिसको जो ऑपोजिशन है, करंट ऑपोजिशन विच इज़ द PTI एंड पाकिस्तान मुस्लिम लीग काफ इन पंजाब, इन्होंने चैलेंज किया इन द ऑनरेबल सुप्रीम कोर्ट. जो बड़ी एक तगो दो के बाद पिटिशन लगी, उसकी समाअत 2 दिन से चल रही थी, और इसका जो है वो हाईली एक्सपेक्टेड आया. और ये मैं समझूंगा कि वन ऑफ द ओनली पिटिशंस इन द पास्ट 2-3 ईयर्स जहाँ पे जिसकी जो आउटकम है वो ऑलरेडी जो जूरिस्ट्स हमारे थे, जो हमारे लीगल एक्सपर्ट्स थे, ये ऑलरेडी एक्सपेक्ट कर रहे थे. एंड दिस वाज समथिंग विच वाज ऑलरेडी एक्सपेक्टेड बाय a legal mind and which could very easily be expected by a legal mind, क्योंकि इसमें कोई ऐसी जो है वो टेक्निकल बात नहीं थी, स्ट्रेट फॉरवर्ड एक चीज़ थी. एक मामला जो सुप्रीम कोर्ट ने पहले से रेस्ट कर लिया था, उस मामले को जो है वो दोबारा से हम समझेंगे रिकरिंग पिटिशन थी. मेरे सामने ऑर्डर मौजूद है, जिस ऑर्डर की बहुत बातें हो रही हैं, अभी मीडिया में भी चल रहा है. और मेरा ये माइंडसेट है कि जब भी इस तरह की बात हो तो आपको उस पर इंटरप्रिटेशन अपनी और अपनी जो है वो जो एक रीडिंग है वो आपको ज़रूर प्रेजेंट करनी चाहिए. ये मेरे सामने सुप्रीम कोर्ट का ऑर्डर है 26/7 का. बेंच जो है द मोस्ट फेमस बेंच, जिसको अपोजिशन ने बॉयकॉट भी किया ऑन द वेरी फाइनल डे, और उसकी भी इम्प्लिकेशंस मैं बताऊंगा कि उसकी इम्प्लिकेशंस होती क्या हैं और उसकी लीगल पॉइंट ऑफ व्यू से क्या तमाम चीज़ें हो सकती हैं. जैसे उमरता बंदयाल साहब हेड कर रहे थे, इजाज़ुल हसन साहब थे, मुनीब अख्तर साहब थे. ये बेंच जो है दिस ट्राइको, ये जो ट्राइको है ये हमारी पास्ट जुडिशल हिस्ट्री में वन ऑफ द मोस्ट इम्पॉर्टेंट ट्राइकोज है फॉर द पास्ट 2-3 ईयर्स. और इसमें जो पिटिशनर्स हैं उनकी साइड से ऑब्वियसली जो PTI वगैरह हैं इनकी साइड से अली ज़फ़र साहब पेश होते रहे, और एक नंबर जो है वो लंबी तवील लिस्ट है. रिस्पॉन्डेंट की तरफ से इरफान कादिर साहब पेश हुए, CM पंजाब जो हमजा शहबाज साहब है, इनकी तरफ से मंसूर उस्मान अवान साहब, हाईली क्वालिफाइड लॉयर, और इन्होंने जो है वो बड़े अच्छे और बड़ी डिसेंट और बड़ी एपॉलिटिकल आर्गूमेंट्स प्रेजेंट किए सुप्रीम कोर्ट में. वी मस्ट अप्रिशिएट द जेंटलमैन. इवन सुप्रीम कोर्ट में द ऑनरेबल चीफ जस्टिस हिमसेल्फ वाइल हियरिंग द केस एक उन्होंने इन पे जो है रिमार्क पास किया, and he I would say he really appreciated the man by saying that he is very mature even in his youth, क्योंकि उनकी एज इतनी नहीं है. लेकिन एनीवेज पंजाब गवर्नमेंट की तरफ से जो है ऑब्वियसली आपको पता है एडिशनल AG और तमाम ये थे. अच्छा जी, ऑर्डर 26/7/2022 का है. उमरता बंदयाल साहब ने ज़ाहिर तहरीर की है बीइंग द सीनियर मेंबर, और इसमें पैराग्राफ नंबर 1 में देख रहा हूँ. फुल बेंच ऑफ द लर्नड हाई कोर्ट वाइड जजमेंट डेटेड 30/6/2022 पार्टली अलाउड सर्टन रेट पिटिशंस इंटर एलिया डायरेक्टिंग दैट द सेशंस ऑफ द पंजाब असेंबली बी रिज्यूम्ड on 1/7/2022 Friday at 4 p.m. to hold poll in terms of Article 130 subsection 4 of the Constitution of Islamic Republic of Pakistan 1973. The said election was a runoff in terms of the proviso to Article 130 subsection 4 I bid for the post of Chief Minister Punjab to be held between the respondent number 2 Hamza Shahbaz Sharif PMLN and petitioner PMLQ. A petition filed before this court against the said order dated 30/6/22 was disposed of on 1/7/2022 by consent order जिसमें तमाम पार्टीज़ ने अपनी कंसेंट दी. इट वॉज एग्रीड बाय and between the petitioner and the respondent number 2 as well as the coalition partner of the petitioner that the runoff election would be held on 22/2022 after the by-election on the 20 general seats in the Punjab Assembly vacated by the PTI members whom the ECP had declared as defectors. Both the petitioners and the respondent number 2 agreed to the continued function of the respondent number 2 as the Chief Minister of the province in a fiduciary capacity until holding the runoff election. It was further agreed that the election would be held under the charge and supervision of the Election Act and the Code of Conduct of ECP. It was further directed that the election process would be completed in accordance with the schedule announced by the ECP, which would issue notification of the final result accordingly. ये बड़े इंपॉर्टेंट जो डिस्क्रिप्शन है, ये 11 पेज का एक ऑर्डर है. इस पे डिबेट अब टीवी पे काफ़ी सुनेंगे, लेकिन ये ऑर्डर हमारे सामने रखने का मकसद ये है, स्पेशली जो लीगल माइंड्स हैं या जो लॉयर्स ये देखेंगे उनको, ये इसमें हमने काफ़ी चीज़ों की समरी उन्होंने दे दी हुई है, जो चीज़ें हमारे लिए इस ऑर्डर को और इस लीगल एम्बिट को, ये जो तमाम लूप होल है, ये जो तमाम एक लूप है, विच इज़ आई वुड कॉल इट अ लूप ऑफ लॉ, ये जो लूप हमारे इर्द गिर्द स्ट्रिंग आ रहा है, इस लूप को एक्सप्लेन किया हुआ है. अच्छा, पैराग्राफ नंबर 2 में लिखा हुआ है, द रन ऑफ इलेक्शन हेल्ड ऑन 22/7/2022 द पिटिशनर सिक्योर्ड 186 वोट्स while the respondent number 2 got 179 votes. This is very important paragraph which is recorded in the impugned ruling of the deputy speaker dated 22/7/2022. ये जो 22/7/2022 की रूलिंग थी, इसको इम्प्यून किया था, इसको चैलेंज किया था पिटिशनर्स ने, जिसमें डिप्टी स्पीकर साहब ने कहा था कि हमें PML जो काफ है इनकी तरफ से, हमें इनके पार्टी हेड की तरफ से लेटर आया, जिन्होंने एक डायरेक्शन दी और कहा है कि ये तमाम वोट्स जो हैं ये अपनी पार्टी को ही नहीं डाल सकते. तो एक डिबेट आई 63A के ऊपर और पार्लियामेंट्री लीडर की इंपॉर्टेंस और पार्टी हेड की इंपॉर्टेंस के ऊपर. हाउएवर द डिप्टी स्पीकर एक्सक्लूडेड 10 votes in favor of the petitioner from count, as a result of which he announced the winning candidate for the slot of chief minister to the respondent number 2. The votes were excluded on the basis that 10 members of PMLQ had failed to follow the direction under Article 63A 1B of the Constitution given by the party head of the members of the parliamentary party PMLQ. As a result of the winning candidate, who had received 186 votes, lost the election by 3 votes. The deputy speaker's ruling was challenged before the court on 23/7/2022. After the preliminary hearing, the matter has been heard at principal seat on 25/7/2022 and 26/7/2022, which is today. We have arrived at the conclusion that follow after hearing the learned counsel for the petitioner and the learned counsel for the respondent 1 to 3 at Islamabad. It may be mentioned the learned counsel for the respondent raised an objection to the hearing of the matter by a 3-member bench of this court and sought the referral thereof to the full court. However, while explaining the ground for making its request, the learned counsel for the respondent 1 and 2 also laid out the cases on the merits of the dispute, which essentially concern a question of law touching the formation of the provincial government, allegedly in violation of provisions of the Constitution, in particular Article 63A read with 130 subsection 4 thereof. Fifth paragraph में कहते हैं, although elaborate submissions were made in terms as above yesterday, 25/7/2022 requests were made by the learned counsel for the respondent interveners for further time to make additional submissions in any and seek instructions. We accordingly adjourned the matter for today, 26/7/2022 at 11:30 am to give the learned counsel for the respondents interveners a further opportunity to add their submissions on the merits of the case if deemed appropriate by them. However, when the matter was taken up, ये जो boycott का बात यहाँ पे आएगी, at 11:30 am the learned counsel for the respondents as well as interveners one by one stepped forward and informed the court that their respective client had instructed them not to participate further in the proceedings in this case. However, in the first session, which continued for about an hour and 45 minutes, they did not withdraw from the courtroom and observed further proceedings in the matter, during which we had further arguments of the learned counsel for the petitioner, especially in relation to submissions that had been made by the learned counsel for the respondents interveners on the previous date and the reliance placed by them on the following judgments of this court. District Bar Association Rawalpindi versus FO versus Federation of Pakistan, PLE 2015, SC 401, Sardar Sheikh Bahadur Khan versus Election Commission of Pakistan. These are the cases that they refer to. While we will deal with these decisions in our detailed reason in support of this short order, we would not be out of place to say something here with regard to the first of the aforementioned judgments. कुछ judgments refer की गई जिसका वो कर रहे हैं. Much emphasis had been laid upon the judgments of the full court delivered in the case of District Bar Association of Rawalpindi, both on the merits and as a ground for placing the present petition for hearing before the full court. The said judgment adjudicated as presently relevant the vires of the 18th Amendment to the Constitution. By majority, the 18th Constitutional Amendment was upheld. In the said majority, one judgment authored by Justice Sheikh Ahmed Saeed was agreed to by the 7 other judges. However, it is to be noted that since the matter was heard by a full court of 17 judges, the majority for the purposes of determining the ratio dash and die of the court had to have the concurrence of at least 9 judges. ये रीज़न दिया है कि फुल कोर्ट क्यों नहीं बना. द रिस्पोंडेंट इंटरवीनर्स हैव रिलाइड ऑन द पर्टिकुलर ऑन पैराग्राफ 112 ऑन द जजमेंट ऑफ शेख अजमत सईद खान Azmat Saeed to contend that it had been laid down therein that the decision of the party as to how to votes has been conferred upon the party head, and basing themselves on these words, they submitted that the ruling of the Deputy Speaker dated 22/2022 was correct. In our view, judgment in the District Bar Association requires consideration on two planes. Firstly, as to whether it constitutes a binding precedent such as would constrain this bench and require us to follow the same in preference over the short order dated 17/2022 as regards Article 63 of the Constitution prescribed action and the consequence that such conduct would attract. Paragraph 112 referred to above, in particular the above quoted word relied upon do not form part of the ratio dicendi and the court since subject to रेशो डाइसेंडाई नहीं है वो, मतलब कि रीजंस नहीं है जजमेंट के. रेशो डाइसेंडाई होता है रीजनिंग ऑफ द जजमेंट. On the other than the 8 judges who signed the judgment authored by Justice Sheikh Azmat Saeed, 6 other judges also gave judgments dismissing the challenges to the 18th constitutional amendment. Learned counsel for the petitioner has taken us to each of the judgments to submit that none of the judges have dealt with this particular point, which is as to whether the party head can give any direction as contemplated by Article 63a(b). Therefore, on this point, the judgment being relied upon does not constitute binding precedent. The other aspect with regard to this paragraph read with paragraph 113, which was also made part of the submission by the learned counsel for the respondents, interveners, was that one of us, Umar Tabandial, Chief Justice, was also one of the 8 judges who signed the judgment authored by Justice Sheikh Azmat Saeed. It was suggested that therefore this was yet another reason as to why the petition before us ought to be placed before the full court. We have very carefully considered we have very carefully considered this aspect of the matter, since it relates not just to a question of law but also of propriety. In the end, we have come to the conclusion that the submissions made in this safeguard cannot be accepted. This is so for the multiple reasons which will be elaborated upon in the detailed reasons. At present, it suffices not to note that observations in paragraph 112 and 13 of the judgment have no relation with the question of vices of Article 63a of the Constitution that was under consideration as set out in paragraph 105 of the judgment. The said question is squarely dealt with the answers in paragraph 111 of the judgment with reference to the ratio dicendi in the Wukla Mahasbarai Tahaffuz Dastoor versus Federation of Pakistan. Secondly, the observation in the judgment being relied upon with respect to Article 63a are discordant with the actual provisions thereof on the subject of the issue of directions to the member of the parliamentary party. In that sense, the observations, even if they had had binding effect, would have been per incurium. In the above situation, the observation in paragraph 112 and 113 of the judgment are passing remarks not bearing relevance to the matter of vices, nor explicating the actual or true words of the constitution. कहना वो ये चाह रहे हैं कि जो रिस्पोंडेंट्स हैं उन्होंने कोई प्रॉपर जजमेंट ये हमें कोई दलील पेश नहीं की कि क्यों जो क्वेश्चन है वो फुल बेंच के सामने रखा जाए. Thirdly, if a judge has unconsciously followed an incorrect view of law, he has by conscious application of mind the freedom to adopt the correct view of law subsequently. वो कह रहे हैं अगर जजेस से गलती हो जाए तो वो फिर भी उसको करेक्ट कर सकते हैं through a relevant obviously the course of law. Fourthly, in the said case, the concurred member of the bench, Umar Tabandial, Chief Justice, wrote a separate opinion in which other constitutional provisions that were under challenge were treated at length, but no notice at all was taken on Article 63a or the 18th constitutional amendment. This reflects the significance of the said constitutional provisions, as evidenced also by the opinion of Chief Justice Nasrul Mulk, Justice Aswad Khosa Saab and Justice Ijaz Afzal Khan Saab, which also did not consider Article 63A of the Constitution. वो कहने जो आपने रेफर किया वो 63A से रिलेटेड था ही नहीं, तो that is not relevant in our case. 10वें पैराग्राफ में आते हैं. As a last resort, learned counsel for the respondent interveners also relied upon the judgments. उन्होंने 4 रीजंस दिए हैं या 5 रीजंस दिए हैं कि हम क्यों नहीं फुल बेंच बनाते. जजमेंट इन सरदार शेर बहादुर खान to support the contention that the party head is relevant to person who has to issue a direction to the member of the parliamentary party under Article 63A1B of the Constitution. However, none of the cited cases substantiate this claim. उन्होंने क्या irrelevant cases submit कराए हैं basically respondents ने. अगर मैं इसको आम words में रखूँ, in view of the foregoing and for detailed reasons to be recorded later and such elaboration and amplification as may be necessary, the titled constitutional petition is allowed. The petitioners की वो allow होगी. The sole question of public importance with reference to the enforcement of fundamental rights involved in this petition is whether the understanding and implementation of the sort of the short judgment of this court dated 17/5/2022 passed in presidential reference number 1 of 2022 read with article 63A1B। ये आपको याद होगा कि जो फॉलो करते हैं मुझे, मैंने एयर वाई में जो इंटरव्यू दिया है उस पर मैंने इस जजमेंट का रेफरेंस दिया था, और ये चीफ जस्टिस उमर बंदयाल साहब ने बार बार रीट्रेट की थी, जो उनकी पुरानी जजमेंट है जिसको इन्होंने अंडर क्वेश्चन लेके आए हैं। ऑफ द कॉन्स्टिट्यूशन ऑफ इस्लामिक रिपब्लिक पाकिस्तान द was correct. We find the understanding and implementation of the said short judgment as well as the provisions of Article 63A1B of the Constitution by the Deputy Speaker, Provincial Punjab Assembly Law respond was patently incorrect and erroneous and cannot be sustained. The governance of the province of Punjab in accordance with the Constitution has been subverted, whereby the fundamental rights of the people have been seriously infringed. वो कहने जो हरकत की गई by the Deputy Speaker which is respondent, उनकी तरफ से बहुत ज़्यादा Deputy Speaker respondent 1 है पंजाब set aside and declared to be void. As a result, the ruling dated 22/7/2022 issued by respondent number 1 Deputy Speaker is hereby dismissed, is set aside and declared to be void without lawful authority and of no legal effect. In consequence of the above, having admittedly secured 186 votes as against 179 votes obtained by Mr. Hamza Shahbaz Sharif, respondent number 2, the runoff election of the Chief Minister Punjab held on 22/7/2022 pursuant to the consent order of this court dated 1/7/2022 passed in civil petition number Flana Chaudhry is later been declared as a duly elected Chief Minister Punjab। जो हैं परवेज़ इलाही साहब, उनको ड्यूली इलेक्टेड चीफ मिनिस्टर ऑफ पंजाब बना दिया गया। वी डायरेक्ट चीफ सेक्रेटरी पंजाब रिस्पॉन्ड नंबर 3 टू इमीडिएट एंड फोर्थविथ and on announcement of this short order issue the requisite notification declaring the petitioner as the duly elected Chief Minister of Punjab. In consequence the foregoing, it is declared that respondent number 2 not being fully elected Chief Minister, the oath of office administered to him was and is without lawful authority and of no legal effect. Likewise, all acts, deeds, things attended and consequent upon such oath, including but not limited to the notification of respondent number 2 and the formation of the and swearing in of the cabinet of his advice, is also declaring to be without lawful authority and of no legal effect. All advisors, special advisors and special assistants, if any by whatever name called, appointed by on behalf of under order advice respondent number 2 shall immediately and forthwith cease to hold office. Respondent number 2 is their appointment declared illegal without lawful authority, and respondent number 2 the person appointed as minister on his advice and the aforementioned persons are relieved of their offices posts with immediate effect. We direct the Governor of Punjab to arrange the administration of oath to the petitioner as duly elected Chief Minister of Punjab in accordance with law and the Constitution not later than 11:30 p.m. tonight, 26/7/2022. In case the Governor of Punjab is unable or unwilling to administer such oath, the President of Pakistan may forthwith administer the oath of office to the petitioner as Chief Minister of Punjab. All acts, deeds, things lawfully done or purported to be respondent number 2 or member of Provincial Cabinet, the office shall immediately communicate, transmit a copy of this order to Governor of Punjab, respondent number 1 Deputy Speaker, Provincial Assembly of Punjab Lahore, as well as respondent number 3 Chief Secretary Punjab for implementation and compliance with the same. Chief Justice साहब के साइन हैं और ये तमाम चीज़ें। Basically the order has basically declared the Chief Minister of Punjab has declared परवेज़ इलाही साहब as the Chief Minister of Punjab who was the petitioner in this petition, और उनको चीफ मिनिस्टर बना दिया गया और डायरेक्शन दे दी गई गवर्नर को कि गवर्नर इनका 11 से पहले ओथ लेगा, 3-4 घंटे में मतलब ओथ लेगा, और अगर वो ना लिया गया तो जो प्रेसिडेंट ऑफ पाकिस्तान है वो सामने आके इनका ओथ ले लेगा। आई थिंक दिस इज़ द केस वाज टेकन फॉरवर्ड एट अ प्रिसाइज एंड रेलिवेंट स्पीड, और ये दिस इज़ द क्लोजिंग ऑफ वन ऑफ द मोस्ट नोटोरियस एरा ऑफ लीगल मिस्टेक्स बीइंग डन इन पंजाब। और मैं समझता हूँ कि कोर्ट हैज़ करेक्टेड द मिस्टेक्स once again done by the legislature and the executive in pursuance of their political purposes. Thank you.